What's up, everyone? My name is Nanad, and I'm a legal intern at LEXIS and Company, and I'm also a student of the Maharashtra National Law University, Mumbai. Today, we will be talking about the general rules of succession in Muslim law. So, let's get started. Now, Muslim law has a very diverse format for succession. Its various schools have different ways and methods of succession. They have devised their own mechanisms, but a few general rules of succession can definitely be found and distilled throughout the ambit of generic Islamic succession law. These are: number one, no, there is no concept of any ancestral property in Muslim law. As such, all kind of ancestral property and self-acquired property is considered one and the same. Thus, whenever a Muslim person dies, all of their property, be it self-earned or ancestral, so to say, simply devolves onto their heirs, and they become the absolute owners of that property. That is their share in that property. The succession pattern continues in the same fashion through generations without any change at all. Number two, there is no particular notion of a right to inherit or succeed in the property by birth. No member of the family has any interest in the property of the testator before the death of the testator. It is only on the death of the testator that a right in property can be invoked. Number three, all of the property that is left after the payment of all the funeral expenses and also paying off all the valid debts out of the property of the testator is considered as heritable property. But under Muslim law, there is no distinction in the kind of property that can actually be inherited by the heirs of the dead testator. In simple terms, it can be said that there is no particular difference between any form of movable or immovable property of the dead testator, and both can be inherited in the same fashion. Number four, there is no particular rule of primogeniture in Muslim law. Primogeniture, in a sense, refers to the concept of special privileges being granted to the eldest son of the deceased person. Usually, it simply means that the eldest son has an exclusive right over the dead father's or dead testator's property. But under Muslim law, there is no such rule of primogeniture, and all the sons of the dead testator are treated equally. Only in the Shia law does the eldest son get the special privilege of receiving his father's sword, his ring garments, as well as his copy of the Holy Quran, but only as long as the son is of a sound mind and that the father has left behind some other property excluding the above mentioned ones. Rule number five is that a child in the womb of a mother is competent enough to inherit property on the condition that it is born alive. The child in the womb, that is in its embryo form, is still considered a living being, but if such child is not born alive, then the right to property vested in the child divests automatically. All subsequent proceedings are in the manner that it is presumed that there was no such heir present to the property in the first place. Rule number six is also known as the doctrine of representation. It simply means that it is a principle wherein the son of a predeceased son automatically gets the right to represent his father in matters of inheritance of property. Rule number seven is regarding the simultaneous death of two or more heirs. So, whenever two or more heirs die in such a situation that it becomes impossible to ascertain who has survived whom, all these heirs are considered to have died simultaneously, that is, in the same moment, and are deemed to not be each other's heirs at all. Now, in the same line of action, it is also considered that these heirs have had no existence at all. Thus, the partition opens without taking these heirs into account. That is, partition opens by considering that these heirs were never present or did not exist at all. Rule number 8 is regarding missing persons or heirs. So, whenever a Muslim person has not been found for more than 7 years with no proof of them being alive or having been furnished whatsoever, such a person can be presumed dead. If such a person was a testator, then the inheritance process for their heirs can be initiated automatically. But if they are heirs themselves, then the presumption of death can be directed into the omission of their existence when the inheritance process is initiated. According to rule number 9, in Islamic succession, stepchildren are not entitled to inherit from their step-parents at all, and vice versa. That is, step-parents are also not entitled to inherit from their stepchildren. But simultaneously, step-siblings are allowed to be competent inheritors of each other's property. Muslim law hence provides for mutual rights of inheritance between uterine and consanguine brothers or sisters. Rule number 10 states that whenever a Muslim contracts their marriage under the Special Marriage Act of 1954, they cease to be a Muslim for all purposes of inheritance. Accordingly, whenever after the death of such a Muslim person, the property does not devolve at all under the Muslim law of inheritance. The inheritance of such properties of such Muslims is thus governed by the provisions of the Indian Succession Act of 1925. Now, it has to be kept in mind that this list is not exhaustive at all. There are many more nooks and crannies throughout Muslim law in general and the succession laws in particular that deal with very minute intricacies and that can change the outcome of any form of inheritance scenario coming under the ambit of Muslim law. Hence, it is to be kept in mind that this list is not all there is to Muslim law, and there are various different forms of rules and various factors that have to be taken into account whenever one is dealing with inheritance scenarios. That is all for the video. I hope you learned something from it. Do like, share, and subscribe if you did. It helps us out a lot. Do comment down below what you think about the video, any suggestions, any queries whatsoever. That's all. Thanks for watching. I hope you have a good one.